Morning, everybody, and welcome to March, and welcome to spring on a glorious day here in Christchurch. I don't know what it's like for the rest of you, but I hope you're experiencing similar. I can't believe we're sort of halfway through this first cycle of sessions now already. This is session 5 of this first set of 12 employment coffee briefings that we thought we would give a go at doing. Obviously, our last 2 sessions we were looking at discrimination, we talked about protected characteristics, and we talked about the unlawful conducts and the things that we are supposed to do and supposed not to do in relation to people with protected characteristics. As I said at the time, looked on those early simply because they do have that influence on everything that we do moving forwards, including today's topic, performance and capability. As always, for those of you who've been on the session before and for those of you who haven't, this is a slightly different system that we've been trialing. It's obviously not Zoom or Teams. We do have a chat function which can be seen by everybody. Feel free today to make use of that. We do also have a Q&A box which is only seen by me. So again, if something crops up in the middle of the session and you decide you want to ask me a question about it, by all means stick it in there or use that as an opportunity to engage and interact in response to anything that I might say. So today's session, as I said, performance and capability. There is I think, maybe certain irony of me talking on this topic because, of course, it's something that most of you probably deal with on a day-to-day basis much more often and much more regularly than I do, with any luck. So how I thought I would approach today's session is to take a slightly broad approach to it, talk about it obviously from a slightly more legal perspective, maybe give a few of my own controversial opinions and some comments on best practice, but we'll see where it goes. What I will say is this is a venue where I'm quite happy for people to share ideas and give their thoughts. So if you do want to make use of the chat function to maybe share some of your best practice points or respond to anything that I say as I go along which you think would help other people, please do feel free to do so. The more we all share, the more we get out of all of these things, and the easier all of our lives become when it comes to dealing with difficult situations. So today's session is going to look a little bit like this. As always, I'll start with sort of the legal framework and the things that we're interested in as lawyers and the things that you should be aware of in the back of your minds when it comes to dealing with performance and capability issues. We'll move on to discussing the distinction between those two things, the difference between a performance management process and capability proceedings, touching, sort of pulling back, I suppose, a little bit on some of the legal considerations in performance matters, turning that into more of a discussion around when it strays into capability, and towards the end we'll take a slightly more practical approach. I've called that their legal procedures and process. This will overlap quite significantly with what you're doing internally, best practice, and what we all sort of expect these processes and procedures to look like. So my screen now doesn't want to react. Here we go. Key legislation. I always stick this slide in when we're covering a newer topic. Obviously, the last 2 sessions I didn't bother as much because it was basically the Equality Act. But for the purposes of performance and capability, we are concerned with the Employment Rights Act, particularly Section 98, which is where we get fair reasons for dismissal. Of course, capability being one of them. We're always cognizant, as I was saying at the start, of the Equality Act and the impact that it can have on any process or procedure that we undertake internally. And I've also mentioned the Health and Safety at Work Act there, which I will come on to shortly. Again, it's one of those ones that is always sort of there in the back of our minds, but perhaps we don't explore as much as we should in certain situations. So let's have a look at a little bit more detail on this. Capability. Of course, if we're talking about capability, we are talking about the potential for our situation to resolve in a dismissal. It could well be that we are starting the process with a view to go down that route, but we're not supposed to. We all know that happens. But it could well be that the end result of any performance or capability process is that an employee is being dismissed. That being the case, we are also conscious of the fact that any dismissal is capable of being unfair if the employee has the requisite 2 years service and we don't show a fair reason for dismissal. We're usually, I think, quite familiar with the definition for a conduct dismissal, and I sometimes think some of the others go by the wayside a little bit. So of course we know for a conduct dismissal, we're looking for that reasonable belief that somebody is guilty of the thing they're accused of, and then that a dismissal, if we get there, is within the range of reasonable responses available to the employer. For a capability dismissal, we're talking about issues that, and to quote section 98 there, relate to the capability or qualifications, and that's my emphasis of course, of the employee for performing work of the kind which he was employed by you to do. Obviously slightly different definition from conduct because we're looking at a different issue, but when this document and when the legislation was drafted, it did envisage these two sort of distinct issues, capability and qualification, both of which we'll come on to define in a moment. And as I said at the bottom there, this is the basic legal test. This is what a tribunal will look at first. Have we reached this threshold? And if this is not established, there's a potential claim for unfair dismissal there. So always being mindful of that is obviously important, and that's our starting point when we're considering capability or performance process that may result in a dismissal. That is in fact the definition that the Employment Rights Act gives us for capability there. Capability is assessed by reference to the skill, aptitude, health, or any other physical or mental quality of the individual concerned. I mean, straight away there you can tell this legislation predates the Equality Act. I don't think we'd be using the phrase mental quality if we were drafting legislation these days. But that is where it is. That is the definition that we've got. And of course, that gives us quite a broad range of issues that can fall within that sort of very, very small word of capability that just sits there in the legislation. And this is where I think, and I will come on to say shortly in this section, really, that we need to perhaps draw a little bit of a distinction between performance management and capability, because there is clearly some overlap here, which we can spend some more of today exploring. But yeah, that's your definition. And as I say, it's quite broad there. You've got plenty of options in there. Skill ultimately boiling down to ability, I suppose, and similarly aptitude. But then you've also got these more external factors that were envisaged at the time of drafting the legislation. So I mentioned the Equality Act at the start. The Equality Act is, of course, a recurring theme whenever we're talking about internal workplace matters, because, of course, there is always the opportunity for somebody to raise a discrimination claim, even if they don't have the requisite 2 years of relevant employment. So do always consider the impact of protections under the Equality Act, particularly in relation to disability when we're talking about performance, something I'll come on to again to explore in more detail in the session. I would suggest also we often sort of see cases around capability and performance management that are somehow linked to age as well. There's quite a few reported cases involving often the NHS and older members of staff who feel as though they've been, to use the classic phrase, performance managed out of the organisation, and that they actually believe that the issue was they were simply deemed too old to train or develop their skills further. So as I said at the bottom there, a dismissal could technically be fair. You could reach that definition under the Employment Rights Act. You could well have established that there is a capability issue, but still be discriminatory, either because of Section 15, something arising in connection with a disability that we discussed in last month's session, or under Section 20, that in implementing the performance process or the capability procedure, you have failed in your duty to make reasonable adjustments, obviously both of these relating to disabilities. Where they are brought as age claims, they are often brought as indirect discrimination claims, or in some cases harassment if something is said during the course of a performance process that the employee finds inappropriate or offensive and is somehow related to their age. So again, important to be aware of all of these in the background, as we always are when it comes to any internal process. I said I'd talk about the Health and Safety at Work Act, and I said it's one of those pieces of legislation that, well, we often have all the posters stuck up around the building, don't we? And we leave them there, and then we go, we've done our bit, we've got a first aider. We won't sort of worry about this too much, apart from understanding our general principles, or if we're working in a particularly affected workspace, then knowing the particular rules and regulations that relate to that work environment. That said, this is right at the start of the Health and Safety at Work Act 1974. It's section 2, so it's immediately there after all the introduction waffle. And this is what it says: it shall be, i.e. it is absolutely the duty of every employer to ensure the health, safety and welfare at work of all of their employees. Again, another piece of legislation that you can tell was drafted pre-equality legislation, his employees. But the point that we really need to draw from this is that is the overarching duty here in relation to health and safety. It doesn't matter what other regulations may or may not apply to the workplace you're dealing with. There is this underlying duty to ensure this health, safety and welfare of all staff. How does it overlap with performance or capability proceedings? Well, what's to you one of your biggest causes of absences or performance issues? We can talk quite easily about sort of back pains and colds and coughs and flus, but one of the leading causes for sustained absence and sustained performance issues is ultimately work-related stress. And work-related stress falls within this and not causing excessive stress on an individual, such as to affect their mental health, safety and welfare. Not the easiest claims, as we know. Stress by itself isn't a disability. Stress by itself is a normal response to the pressures that we all experience in day-to-day life. But when your employee raises that grievance in response to the performance process and they start talking about the duty of care you have to them, this is what they mean. And it is something to be mindful of, particularly in performance processes, if there is a chance that the performance or capability issue that is underlying your process or procedure could actually be being caused by stress at work. Claims under this legislation are relatively rare, but they do get cited in an employment tribunal, usually in relation to an unfair dismissal or a disability claim. Okay. The other legal considerations to have in mind don't come from statutes, but come from your actual relationships with your staff or the employees that you might be dealing with. Contractual obligations. These, in theory, should not be there to the extent that we are concerned about in most employment contracts, and most of these will only exist in senior contracts, but it is worth bearing in mind that there may be contractual obligations on the employer in relation to performance and capability processes. Training should now be, thanks to the Good Work Plan changes, there should be reference to training in every employment contract. Mandatory training must be in there, as well as who pays for it and on what basis it's delivered. Therefore, if you have a training obligation in your contract and you as the employer fail to deliver on that, the performance process itself is potentially both unfair and also a breach of contract, because the loss, i.e. the dismissal, the loss to the employee, is ultimately caused by your failure to comply with your contractual obligation to provide that training. One to be obviously mindful of moving forward, particularly as sort of post 2018, 2019, we started to see these going into contracts increasingly as people catch up with the legislation. And of course, people are now reaching their 2-year mark who will have been on these contracts when they were sort of rolled out properly, I suppose, post-pandemic. Performance management processes. Again, it's one of those ones where we sort of know the position when it comes to disciplinary and grievance procedures, and we're all very good at writing policies that say these are non-contractual, despite the fact that we all know a tribunal will generally look at them and go, they're quasi-contractual. Performance management processes are exactly the same. If you have got a regular system that you follow and there is an expectation that the employee would be put through that process and everybody else is, there's a risk of it being quasi-contractual. If it is specifically in there that the performance management process is done in a certain way and that is not done, then of course there's a risk there as well. And overlapping here with sort of bullet point 3 there, if there are performance management expectations, if there are performance goals, and there are processes and procedures that are set out in the contract, which are also inherently linked to, for example, pay review, and those processes aren't followed, there is a potential breach of contract claim there as well. Employee turns up in the tribunal, in the High Court, in the County Court, and says, there was a breach of contract, my performance management processes that are set out here in my contract weren't followed, and as a result, I didn't get the pay increase I expected over the last 5-6 years. There's suddenly a risk of quite a valuable claim there. So do be mindful, because those may well exist and be laid out much more clearly in senior contracts. And I have seen them in things like director service agreements as well. And of course, the value in those is significantly higher, which means so is the risk. The last one to mention on contractual obligations, of course, is trust and confidence. This is one that is implied into every employment contract, that both parties will behave in a way that we would expect of an employer and employee. Each party will be looked after accordingly. The thing with trust and confidence to be mindful of is it's what gives rise to constructive dismissal claims, again, where an employee has had 2 years. Misuse of a performance management process, overzealous use of it, poor implementation of it can all give rise to an employee going, ultimately, you know what, I've had enough, you're not treating me appropriately, I'm losing trust and confidence in you, so I'm going to hand in my notice. I do an entire session on constructive dismissal, so I'm not going to try and cover it in detail here. They are not the easiest claims of all time for an employee to bring, and of course inherently they rely on the employee making themselves unemployed, but it is again one to be mindful of, and where an employee has no other option but has been treated poorly, they will look at bringing trust and confidence arguments. Last thing to always be mindful of, I'll touch on it right at the end of the session instead. Do be aware, of course, data protection requirements, Data Protection Act and GDPR. This is very much about who has access to the information as you go through the performance process or the capability proceedings, with whom it's shared, and how long you are retaining that information. So let's move on. I'm going to throw this one out. Feel free to put something in the Q&A. Feel free to put something in the chat, but this is me being an incredibly horrible person and asking you a question that I'm curious about answers, I think, rather than there necessarily being a right or wrong here. Performance management and capability issues. I'm just going to keep talking. Feel free to sort of put things in the chat or the Q&A as I go. I think that there needs to be a distinction here sometimes, because I think one of the issues that can arise is we overlap these two things, and I think it results in a lot of the issues that come from the employee perception of the procedure they're going through. Sorry, I'm glancing off to my left because I'm on a different screen setup, as you may have noticed, and everything that you're contributing is over there to me at the moment. So I'm trying to sort of speak and respond to that at the same time. I've got a sort of couple of answers slowly pinging in from people and their thoughts, which is quite nice to see. I'm expecting a couple of classic phrases to come up in response to this as well, which I know are taught by other people and other organisations in doing this. So I'm just going to pause for a second and let people catch up with any comments. Yeah, I'm getting here performance management being about overall performance. Yes, capability often relating to health. Yes. How they're doing their job versus something that stops them from doing so. Yeah, I like that as an answer. I'm waiting for the classic here. I'm waiting for the can't versus won't. Suddenly everybody's going to jump in as I was just about to say that. Yeah, so while that's carrying on, and yeah, again, as I say, feel free to use the Q&A, but obviously if you want everybody else to see it, there is the chat option as well that should be available to you. Yes, thank you, Liz. Can't versus won't for everybody who can't see it. Yeah, okay. Performance management versus capability then. So performance management, yes. Performance management is your internal process. To me, it's, as I've sort of set out here, this is about target setting, expectation management, and ultimately the way in which the employee contributes to the business. Performance management is an ongoing process. It's something the employee should be actively engaged in themselves because, of course, they've got somewhere they want to reach. And it should be something that is ticking through in the background of everything they're doing. Performance management shouldn't come as a shock. It shouldn't come as a once a year thing, let's sit down and see where you are. Effective ongoing management of what an individual is doing for the business and how they are approaching their work is very much one of these things that ticks along throughout their employment. Capability, as we've sort of been bringing up on the other hand, is that more objective assessment. It comes back to those terms in the legislation about the ability of the individual to do their job to a particular standard. If you think about that definition that we pulled up right at the start, it's about the ability to do the job that they were employed to do. It's not necessarily about their willingness to do it. And yeah, as just has been pointed out in the Q&A, if you have somebody if you have someone won't do their job, that is very much a conduct issue, certainly not capability at all. We'll touch on that that point in a moment. And yeah, as was sort of drawing up from some of the comments that were coming out of that question, capability, yes, is going to rise out of either a fundamental lack of skill, that has been lost for some reason or was never in existence to start with, or such as health factors, these sort of external issues, which is going to be difficult for the employee or the employer to manage. So that to me is the distinction. And I think some of the issues that arise and which end up being litigated are where you've got businesses who confuse these two processes. And I will come on to the sort of risk of miscategorizing these in a slide in a few moments. So yes, they are different approaches to different issues. Poor performance is very much about not hitting your internal standards, about not reaching the targets that are set as part of monthly, annual, whatever the case may be, process for you. We are moving very, very swiftly towards recognizing that performance management is actually more about appraisal process and effective intervention than it is about going down some long-winded process where from the start you're telling the individual they are potentially going to be dismissed if they don't improve. Internal issues around not hitting specific targets are, as I've said there, addressed through training, coaching, development. I've mentioned the dreaded PIP. We will come on to that shortly and maybe talk about that in a little bit more detail. But as we say, where the role is ultimately capability, and as we sort of hinted at in the previous slide there, it is more about this fundamental inability to do the job. If it doesn't improve, if it can't improve, if it's not possible to reasonably address the underlying issue that's affecting the ability to do the job, that's where you're starting to talk more safely about dismissal, because it is ultimately incapability. So performance management as an appraisal network. People have their own views on appraisals and performance management. So let's just open this one up quickly. How often? How often do you do some kind of formal appraisal process, and what do we think that looks like? Again, this is one where I'm just curious. I don't think there's a right answer necessarily. Yeah, I've got bi-monthly. Any advance on bi-monthly? And just for the sake of clarity, because I know Americans get confused with this sometimes, when you say bi-monthly, I assume you mean 6 times a year rather than 24. Monthly one-to-one and an annual review. Yeah, minimum of yearly. Monthly one-to-ones, depends on the industry, of course. Yeah, sales background, so weekly formal reviews. Yeah. Problems and then monthly. Yeah, I think we're getting a fairly consistent message here. Yeah, I mean a minimum of annually, of course, and this is the purpose really of performance management and appraisal processes. And I think to an extent you can treat them as overlapping. And that's the idea behind them. An appraisal is about the individual staff member, where they're going and where they sit in the business. It's not sit down shock tactic, your performance is significantly lower than expected. And that is where the issues come from. Issues in employment situations often arise where something comes as a surprise to people. And this is a line we put in our own appraisal process when we circulate it internally. Nothing that is discussed in an appraisal should be coming as a surprise to anybody at all. If an employee doesn't know by their 6-monthly annual appraisal, particularly if you're only doing it annually or 6-monthly, that there is a performance issue, you're doing something wrong in your performance management and your knowledge of where they sit. I mean, yeah, I'm sort of drawn more to the answer that it says perhaps it depends a little bit on the industry and the amount of knowledge and the amount of information that an employee can have about their own performance. I'm quite happy to sort of share what we do internally. Obviously, the most effective way that we can manage performance, albeit an incredibly objective and somewhat commercial one, is billing figures. How much do we generate on a month-to-month basis? That is something that is communicated to us monthly, both in terms of monthly statistics and where we sit annually. It is also a conversation that we have on a monthly basis with someone from the accounts team and one of the senior managers in the business. The kind of more formal appraisal process, yet we do only do annually. We're in the middle of doing them at the moment as it happens, but that is very much from the perspective of where do we sit within the business, where do we as individual staff members see ourselves going, and what needs to be done on that two-way level in the medium to long term to get us to that position. It's an opportunity, of course, to discuss any obstacles to performance. If I had my way, we'd probably do it more often, but that's not my opinion. But you know, that system and that mechanism is there, and the knowledge of performance is something that is regularly and routinely done, both within departmental and senior management level. And of course, as I said at the start, we all know our figures. They're communicated very clearly to us. We know where we're sitting performance-wise. So even if it does take a year to get there, there's no sort of argument that it's a shock. It's a conversation that should have happened much earlier. Yeah, I'm probably more torn towards most industries it being appropriate to do a couple of these a year, but it really does depend on the nature of the individual business, the nature of the industry, and I think, as I said, the amount of information that's already available to staff themselves, and how you choose to manage your sort of team structure as well. So yeah, as we were sort of hinting at earlier, there is obviously an overlap. The performance management process may highlight something that is actually an incapability. You never know if in the middle of an annual appraisal, somebody's going to sit down and explain to the appraiser that there is something going on in the background, that they never had the skill to start with, and that's magically just been discovered somehow. That they've developed a serious medical condition that's going to cause a deterioration in their capacity to do their job in the coming months, and is already doing so. All of these things may come out of a performance management process, of course, in which case the decision needs to be taken as to how to progress that situation and how to deal with it. And similarly, an unsuccessful PIP could start to move towards that incapability and dismissal process naturally. A performance improvement plan, which again is a dreaded term. Employees hate it, as we'll come on to, but it's sort of really the only term we've got for it. It can sit under either performance or incapability process, and of course it is ultimately about target setting. I would suggest one of the biggest differences between the nature of the performance versus sort of the capability process from a target setting point of view is that there is a difference between a challenging target being set to somebody who is performing well and wants to progress, and a realistic improvement target that needs to be set to somebody who's maybe going down incapability or problematic performance processes. So what is the risk of miscategorising these two things? Well, if staff feel they're being unfairly or unreasonably treated, we've already hinted at the potential for constructive dismissal, the potential for grievances, the perception that staff have around performance processes is that you are taking your first step towards trying to dismiss them. And I think that is where there is an important distinction between managing performance as part of an ongoing process and going down a capability route. Most businesses are quite good at this, but the fact that we still have legal claims that arise from these situations suggests that there are obviously issues arising. Right from the start, we've been talking about discrimination, the impact of the Equality Act on these processes and procedures. It goes without saying, but I put it in there anyway, having a disability is not necessarily the same as being incapable of doing your job. None of us think that, I'm sure, but there are people with that mindset and that sort of frame of thought, I suppose. It's very, very common in disability discrimination pleadings or pre-action letters to have a line in there that basically says you're trying to get rid of this employee because you can't be bothered or won't deal with the reasonable adjustments that are needed. And that usually has some element of truth in it when it's actually at the point of getting to a tribunal claim. On the flip side, an overzealous performance management process for someone who's disabled also has its risks. The wrong person following the wrong process here is where the claim is going to arise, because you've got this distinction, I think, as we've been hinting all the way through, between performance management, how do I help this person be the best they can be, and capability, how do I get this person to do their job? The approach is different, the target setting is different, and the understanding is different. Your routine day-to-day performance management process is not necessarily, for example, going to highlight reasonable adjustments. It should, if it's being done and implemented properly, and that discussion is one that can be had openly. But if it's a conversation that an employee doesn't feel they can have with their line manager or whoever is conducting that process, or they don't feel that it's a venue to discuss it, then you've got a risk that basic performance management doesn't highlight things they need. On the flip side, of course, diving straight into an incapability process for someone who's disabled runs the risk of a direct claim, Section 15, or a failure to make reasonable adjustments. Poor morale, I've hinted at before. We'll sort of park the won't do conduct attitude, but again, one of the issues that stems out of lack of general performance is motivation. If you're trying to address motivation by threatening staff with a process that could lead to their dismissal, they are not going to become more motivated to work. And as we said, there are the legal challenges, both actually if capability is treated as simply poor performance and vice versa, because of the things that we've been discussing in sort of the last couple of points there. So what are our legal considerations in performance management first? So let's talk about this from sort of the appraisal day-to-day performance management approach. Needs to be fair, it needs to be consistent. You need to have a methodology that is applied evenly across the business here. If you're going to have 6 monthly appraisals, performance management reviews, do them rigidly, make them compulsory, everybody does them. There is no reason not to. But equally, make sure that people who are conducting them understand the expectation. And that's both ways. Make sure the line manager understands the purpose and what should be the outcomes from them, and make sure that the employee knows what they're walking into and what it should be about. Like I say, I do think it's very important to stress that as part of an appraisal performance management process, nothing that is discussed should be a surprise, because it should be things that we're already aware of. And we're now simply talking about how that progresses. And how the employee gets from where they are now to both where we want them and where they want to be. I'll come on to documentation, record keeping and retention as part of the rest of the session, and legal and practical considerations of performance improvement plans. That overlaps a lot with what we've been talking about already. There are more things that will come up in the next few slides. So Performance improvement plans. I mentioned earlier that performance improvement plans can be done also under a performance management process. They can also sit under capability, and I think it's simply because we haven't got an alternative name for them. A performance improvement plan could arise out of a standard performance management process. To me, they're much more appropriate sat under capability. That's simply because I think performance management done from an appraisal is long-term target setting about becoming where the individual wants to achieve. The capability process is much more about performance improvement. And that's what I said at the start there. If you're going down a capability route, you're addressing their actual ability to do their job. It's not about their motivation. It's not about their development. If they're simply refusing to do the job, you've got the potential for a conduct route there. If the issue is fundamental lack of training or development, and as an employer, there's an argument that you're also at fault there, that is much more appraisal training based. We shouldn't be talking about dismissing the employee because we've not given them the opportunity to improve. That said, every process that you run, and actually it doesn't matter whether we're talking capability, it doesn't matter whether we're talking performance, it doesn't actually matter whether we're even talking conduct here. The initial point is that quite open dialogue. You have noticed a performance dip as an employer. What's causing that? It may well be that there's a much more informal resolution here that can be dealt with, other than going down a formal capability proceeding and all of the associated A, legal risks, and B, stigma that is attached to that. I've said it over the last couple of slides. The employee perception is that if you introduce a PIP, you're trying to dismiss them. Employees just think that. And that now becomes very much around how that is framed and the idea that somebody shouldn't just be hit with a performance improvement plan unexpectedly. Target setting, we all know this, but it is something the tribunal will expect to see. Part of their obligation in a dismissal is still, was it fair in all the circumstances? Well, if you haven't set measurable, reasonable, attainable targets, that is not going to be a fair performance management process. So these are things we've touched on briefly already. So thinking back to performance management, we talked about the contractual obligations earlier in the session. Is there under your contract some kind of regularity process? Is there some kind of particular content that has to be there under a performance management process? And is it somehow linked to pay? Those are the points I made earlier when I introduced the contractual arguments. Do be mindful of the risk of breach of trust and confidence, and do be mindful of discrimination issues that arise in performance management. I've just had one question jumping back to PIP that I'll touch on quickly. What's a reasonable time frame to expect to see improvements? There isn't one set out anywhere in law. You won't find a clear answer to that because it's employment law. And so I will give you the classic employment lawyer's answer, which is it depends. I think the important thing to be mindful of when you're target setting under performance improvement is it's all fine and good going, you're working at 50%, we need you at 100. There's a reason that individual is working at 50%, and it may not be something that can be easily recovered in 1 month, 3 months, 6 months. If it's disability related, reasonable is reasonable in the circumstances. If it's unfair dismissal related, reasonable is reasonable in the circumstances. That is pretty much always what reasonable means. No clear answer. If anybody has a counter opinion to what I've just said there, please do chip in. But ultimately, the problem with performance management and capability dismissals, and again, I'll come on to it in a second, it would always take longer than a conduct route because there is no black and white answer as to how long this should take. How long this piece of string is the question you're asking, unfortunately. So yeah, I mean, we've had an answer, partial answer there. If you've got sort of visibility of clear financial metrics on a weekly basis, then a couple of weeks between PIP reviews, absolutely no issue with that. It's something that you can see on a routine basis. If that's available on a weekly or daily basis, great. Take my example. I'm quite happy to keep using myself as an example for these. our figures are based monthly. There are all sorts of reasons why somebody's performance might dip at certain times of year. It is well known in our industry that conveyancing goes in waves. For example, people don't buy houses during economic downturn. People will either rush to complete before Christmas because they want to be in a property for the Christmas period, and then it may go a little bit quieter in January, although I'm sure they'll tell me it didn't happen this year. Litigation goes quieter in the summer because people go outside and enjoy themselves rather than suing each other. So yeah, it is very much the case that it's sector dependent, work dependent, and individual circumstances dependent as to how long that process will take. Yeah, the expectation, as again, helpful comments just come in, the expectation is that you've got those smart targets that are measurable, that are attainable, that you know that are realistic, and set clear guidance as to what is expected as an outcome there. So yeah, this brings us right back to the question that we were talking about at the start. If performance is based on the will not, which could be motivation related, it could simply be that they just don't want to do the job anymore. You can be looking at this as a conduct issue. Of course you can. Somebody refusing a management instruction and there being no other obvious reason as to why their performance is dipping, either health related or performance more generally, there is a potential for a conduct route there. Capability is very much the cannot. It's the sickness, the skills, the lacking, or the poor training. So legal procedures for any kind of capability process. So this is now thinking back to, look, we're in a situation where there might be a dismissal here. What is it that we actually need to do? Must go through that formal process if the employee has over 2 years service. You don't want to risk an unfair dismissal because you've just made a decision and not reasonably explored the options. It's advised in all other situations because, of course, even someone under 2 years service can still bring a discrimination claim. You don't want to have dismissed someone for capability only to then find out that their line manager knew about a serious medical condition that was affecting their performance or attendance. Drawing on what we were just saying there, a capability process will always be longer than a conduct or disciplinary process, simply because there is that expectation that there will be an opportunity to improve given. Now, what I mean there is that if we look at it in its most simple form, in theory, a conduct or disciplinary process could be completed in a couple of weeks. I know they never are, and I know the investigation drags on forever, but in theory, they could be. A capability process is going to require at least 2 stages of sort of you must improve within this time frame, which, even as we were saying on some of the lesser answers I've had there, that's somewhere 2, 4, 6 weeks, even before you reach what could be the equivalent of a final hearing. Don't forget, there is also the expectation that you will contribute more here. You can't be expected in a conduct process to help the employee improve their behaviour. You can absolutely be expected to be doing things to support an employee in improving their performance or improving their contribution to the business. Again, that will be particularly true if there's a disability related and it's reasonable adjustments. Approximate structure, everybody will have a slightly different one. We all know there's no kind of absolute approach to these, but it is always going to be identify the issue, make that decision as to whether it's conduct, performance, or capability based. You know, is this something that is going to be more effective managed as the employee is refusing to do their work, or is this something that is going to be managed more effectively through formal performance review or capability proceedings? I talked about record keeping earlier. Yes, engaging in dialogue properly. Do always keep a record of your discussion because you never know what an employee is going to say. We talked about target setting and giving a reasonable time frame for improvement there, which again will be sector dependent, will be role dependent, will be individual dependent. And yes, do keep reviewing. Performance management, as we were saying, shouldn't be a surprise. If you've gone down that more performance management approach here, have the one-to-ones, have the touch points, have the feedback. If you're going down a capability process, set it out. You know, stage 1, stage 2, final hearing. obviously giving reasonable time to improve and the opportunity for back and forth engagement to take place between you and the employee during that process as well. Touching briefly on disability discrimination, I won't go into this in a huge amount of detail because it's a massive topic, but don't forget, if at any point you become aware that the dip in performance potentially stems from a disability, there are a lot of legal considerations to have going on in the background here. Reasonable adjustments are on you. The definition of reasonable we talked about in last month's session. The definition of reasonable adjustments and what they can look like is all in last month's session. So if you feel the need, do please review that session in light of this, some idea as to what you might be expected to implement. If it is medical, if it is a disability, then you may need to be seeking medical advice. You might need to send the employee for some kind of medical assessment, check whether that's allowed for under your contract, because that can be quite useful, and or to engage the services of occupational health. Somewhere on the Fretton's YouTube page, I think, there is an extended Q&A panel discussion that I did about 18 months ago, involving me, Paul is my former colleague, Anna Harrington, occupational health specialist, and Ezra McDonald, barrister. We spent a lot of time talking about the role of occupational health, where that sits in internal processes, and indeed how the tribunal view it. I really enjoyed it as a session. I'm not going to tell you it was great because that feels like blowing our own trumpets. But if you're interested in our views on that, and especially those of both counsel and an actual occupational health practitioner, do please have a look at it. And the big important one, again, consider the risk of Section 15 claims. Overzealous implementation of performance processes is one of the most common ways that an employee will try to engage that discrimination arising in consequence of a disability. Again, not going into a huge amount of detail because I covered the definition in last month's session, but the simple approach to this is you've got this target of me, that is your policy, that's your criteria, that's your practice. You might say you're sacking me for capability grounds. What you're actually sacking me for is something connected to my disability, which could be my lack of attention span, it could be my sudden inability to type or read or engage in the mechanical process as well as I used to. If that's established, the reason for the dismissal actually becomes discrimination rather than performance issue. So yes, capability is a potentially fair reason for dismissal. Of course it is, it's there in the legislation. If the issue is the employee will not work, as we said, that could be a conduct process instead, but always be mindful of the underlying reasons for the performance dip. Performance and capability processes will take longer than conduct, probably longer than redundancy, to be honest. And in any situation where you consider dismissal, there is always this expectation that you'll consider the alternatives. It's not a huge threshold, as we know, related to conduct dismissals. Was dismissal in the reasonable range of outcomes available to the employer? It's not a difficult threshold to reach, but in capability, there is an expectation that you will consider steps short of dismissal if they are available to you. Alternative job roles, demotions if the employee will agree, but be mindful of that looking like a disciplinary outcome rather than a capability one. And of course, reasonable adjustments, amended targets, alternative working patterns, all of these sorts of things could assist the employee in reaching their performance targets. Everything there, I think we've covered. The important things are that this is an open and transparent process. It should be about encouraging a two-way dialogue. A capability dismissal is not a conduct dismissal. You're not necessarily accusing the employee of doing anything wrong, and they shouldn't necessarily feel as though they have done. Performance issues should be part of an ongoing monitoring process that is done throughout the business on a regular basis. Hitting an employee with surprise performance issues is a very good way to lose morale, is a very good way to lose their engagement, and is a very good way to risk them bringing either an unfair dismissal or a constructive dismissal claim. I'll highlight data protection very, very quickly. This is a performance management process. Be aware of who has access to the information, why it's being processed, and do bear in mind that if it starts to stray towards medical or disability grounds, that will be special category data. The fewer people who have access to it, the fewer people who need to see it, generally the better. Do think about where it is stored as well, and that is a secure system. Retention period for most processes that are conducted internally, 7 years after the end of employment. A tribunal claim, we know the limitation is only 3 months, albeit realistically 6 by the time they've engaged ACAS, but contract claims are 6 years, 6-year limitation period. So generally we would recommend that retention is 1 year beyond that limitation period, just to be on the safe side. That said, that is always subject to your ongoing data protection obligations to only hold data for as long as you need to. So do review your retention periods when considering capability procedures. Okay, that's been 50 minutes. Unless anybody else has got anything they want to share, comment, or talk about, next session will be Wednesday, the 3rd of April. We'll be looking at the related topic of sickness absences and how you manage those. Again, funnily enough, that will probably have a little bit of a disability slant as well. Unless anybody's got anything they want to add, I'll wrap up there. Enjoy the rest of your morning, enjoy the rest of your day, and I'll see you next month.